Hi, I'm Vincent Rosillo, and I'm a partner in the law firm of Fine, Allen & Anderman. And today, I'm here with Jennifer Safier, who's also a partner in the law firm, and we're going to talk about wills, living wills, power of attorney, and healthcare proxies. Now more than ever, with the pandemic all around us, people have been asking us all sorts of questions. So we thought it would be a good idea to address some of the issues that may be facing our clients and their family members. So Jennifer, welcome, and hopefully we can get some information to our clients and our families. So tell me, what happens if you die without a will?
Well, if you die without a will in New York, then the court will determine what happens to your estate. So there are laws of intestacy that lay out exactly how your property would be distributed. But the problem is it may not be the way that you want. So, for example, New York doesn't have common law marriage. So if you're living with somebody for decades and that would be the person that you would want to inherit everything, they would not be entitled to anything, and a judge could not award them anything because they're not your spouse and they're not your blood relative. You could also have a child that you have no relationship with, and because of the fact that they're your child, they would stand to inherit everything. So it's really not a good idea to let the courts determine what should happen. It's very important that you have proper estate planning.
So we always hear about estates, and it sounds like it's, you have to be a millionaire to have an estate. So what property is included in an estate?
You don't have to have any certain amount of money. An estate's going to include any real property that you own, any bank accounts, any personal property, basically, and those items that they're not jointly held, and they don't have a named beneficiary.
So generally speaking, what property must be included? What else must be included in a will?
So your will should include beneficiaries, which are people that you're naming that you want to inherit whatever it is that you have. You should also include an executor. The executor is the person who's going to carry out the terms of your will, make sure that your property is distributed the way that you want. You should always name an alternate executor, just in case your executor predeceases you or they're unable to act for some reason. You could also name a guardian if you have minor children. You can make specific requests, and you can name a trustee if you're going to leave anything to a minor child.
So, we always see these events on TV and movies where it seems very formal. And how does a will get executed?
So there is a formal execution ceremony that needs to be followed in New York. You cannot just sign a will, just have it notarized. That's not sufficient for New York State. A will has to be notarized and witnessed by two witnesses. And those witnesses have to watch the testator sign. They have to watch each other sign. They then execute an affidavit stating that they did that, and then the notary notarizes that affidavit. That affidavit becomes part of the will, and it's what gets filed with the court. That way nobody has to appear in court because the affidavit swears that the will was executed properly.
So what happens if someone just makes a list of their property and just documents that way where they want it to go?
That list would not be considered a valid or binding will. So nobody would have to follow that list. Nobody would have to follow that directive. Anything that you want to go to a certain person, you would need to include in your will. So your will could include specific requests, such as jewelry or cars, artwork, any sort of collectibles, but it has to be part of the formal will.
So we hear that word probate, and it sounds, again, very intimidating. So what is it exactly?
Probate is really just a simple court process where the surrogate's court looks at your will and makes sure that the terms of the will are carried out. So they give the executor authority to act, and they make sure that the beneficiaries named actually receive what they're meant to receive. It typically is not a lengthy process, and it's not an expensive process either. There's a small filing fee based on the amount that's in your estate, and it's based on the county in which you reside, and it moves forward in a relatively simple fashion.
So that's great. That's great information about a will. I know there are other documents that are important that we recommend that people have. So can you tell me a little bit about a power of attorney?
Sure. A power of attorney is another very valuable tool and document that we strongly recommend people have. So power of attorney is where you appoint an agent, a person who can act on your behalf regarding your finances. So it could be a limited power of attorney. For example, you want somebody to act on your behalf in regard to closing on a house. Maybe you're not in the area and you want to be able to have somebody else to take care of that for you. Or it could be a full power of attorney where you're granting them all authority to take care of your finances, such as paying your bills, speaking to Social Security Administration, dealing with your retirement benefits. Basically, any and all aspects of your finances, the agent that you appoint has the ability to do that on your behalf. There's two types of power of attorneys. There's a springing power of attorney and a durable power of attorney. A springing power of attorney takes effect once you're incapacitated, and the durable takes effect immediately. For the springing, the person that you're using the power of attorney with, like a bank, for example, would ask for documentation that the person is incapacitated. And it would have to be current documentation from a medical professional stating that. So we would not recommend a springing. We typically use durable powers of attorney.
Okay, and does a power of attorney cover the medical?
No. Power of attorney does not cover medical. For medical decisions and medical treatment, you need a living will and a healthcare proxy. These are two documents that go hand in hand. So a living will states your wishes, what you would want to see happen if you were unable to express your wishes, if you were in a coma, for example, or unable to speak and convey your wishes. So it would specifically say what you want to happen, if you want to remain on life support, things of that nature. Then the healthcare proxy appoints an agent to act on your behalf. It appoints a person who can make those medical decisions for you, since if you're unable to make them for yourself for whatever reason. So those are both valuable documents as well.
And we hear the word living will and it gets people confused. So could you just really briefly tell us the differences?
Sure. People do confuse them all the time. So a will takes effect when you die. A will has to do with your finances only, your property only. And what the will does is basically says, this is what I want to happen when I'm no longer here. The living will, along with the healthcare proxy and the power of attorney, those are all documents that are effective while you're still alive. So the power of attorney is regarding your finances while you're still alive. Once you pass, the power of attorney is null and void, and that's when the will would kick in. And the same with the healthcare proxy and the living will. The healthcare proxy and the living will have to do with medical decisions, obviously, while you're still alive.
It's really great information to know for a very serious topic, so I appreciate you taking the time to talk to us. If you have any further questions, we certainly recommend that you contact our law firm. We can give you specific information. You can reach us at www.foalaw.com or 1-800-522-9001. And again, I want to thank you, Jennifer, for taking the time to speak to us.
You're very welcome, Vinny.
Thanks.
Thank you.